right. And one or many of you describe the issue of underprotection of music and dance under copyright law.
Look, one salient example in the issue of dance, of course, choreography. So choreography wasn't protected until the 1978 Copyright Act, right? It became part of the 1970s. Even after that, as they were negotiating, it took what 25, 27 years to negotiate what is the 1978 Copyright Act. So it was a long time. And one of the things that the Congress said is that we don't want to protect so-called social dances. I am 100% persuaded that they were talking about the dances that Black folks do. And this only changed a few years back when Shaquille Knight, who's the choreographer for Beyonce, and he did the Singles Ladies Dance. He was the first African American artist to get a copyright registration in a dance that was not, European oriented. That's one glaring example of how that took place. So remember, we're talking about people in the 1950s drafting the 1978 Copyright Act. They weren't thinking about Black folks. There were no Black people in the room. There probably weren't any women in the room either, by the way, as far as that goes. And so this is the history of copyright law. And on the music side, of course, one big glaring example is the compulsory license. The compulsory license states that whenever a composer releases their composition on a sound recording to the public, anybody on the planet can make their own version of that song, provided they stay faithful to the basics of the song and that they pay the composer. The compulsory license, though, was kind of turned on its head for Black artists because Black artists were generating all the creativity in rock and roll and blues and all the different genres that we uniquely created. And yet, white artists were in a position to uniquely profit because why have Howling Wolf do the song when we can get Elvis to do the song? We'll make a lot more money. You would think that the artists would be happy because they're getting paid for it, but they weren't. Little Richard was very angry about this in particular, that a lot of his songs were covered by white artists, and they didn't even know that he was a creator. And hopefully we get a chance to talk about this later. When we're talking about making changes, one thing that has to change is that we have no mechanism in American jurisprudence in IP that protects people's right to credit, which was another major part of this exploitation. Credit deprivation, not giving people credit for what they did. As we're now talking about a new federal right of publicity, I've been screaming wherever I can, you must include a right to credit with that. Because I've seen personally, I know you guys as attorneys have as well, the devastating impact when someone isn't credited for work that they've done. And there's no legal mechanism to address that besides a contract, which little people don't get.
What I've seen is when an artist has a hit record and there are maybe 10 writers or several writers on that composition, and that record is exploited by the record label, but there isn't proper clearance because they can't agree to the splits. Now, the record label is profiting off of the exploitation of that sound recording, but the writers can't get paid because there's an issue with the splits. And I see this happen time and time again, and that issue doesn't get resolved. And if the writers can't agree, then it's a problem. It gets held up. So how do we resolve that issue? And this is something that we're dealing with in the music industry today. And that's a huge problem.
If I may, if everybody were a Bernie Lawrence Watkins, we'd be in great shape. But what artists don't always understand is that the importance of representation. The music business is very, very complicated. It's evolved in a way over time that there's some arcane practices that continue. There's very complicated laws in terms of, as Professor Green was just referring to, some of the application of copyright law, as Bernie was just talking about splits and how that all works. And it's one of the challenges I've seen over the years is trying to help artists understand the importance of representation and the importance of good representation, and not necessarily going to an individual because everybody else goes to that individual, but going to an individual because they understand and they're looking out for you. And it seems antithetical, but it's absolutely important and critical. And you're absolutely right, Bernie. You could be sitting it's going to be 3 a.m. when, the recording session is over. And it was incredible. I mean, this record's fire. But no one, before they leave the studio, no one's sitting there going, wait a second, I was 5%, I was 7%, I was 8%. It doesn't work that way. It's like, yo, we made fire. And then the record comes out. And one thing I just want to clarify, record companies aren't taking the money that would otherwise go. It's held in abeyance, but it's never going to be released until all the parties can agree on the splits. So then you have, now, if you're someone who's a 2% writer, you got to deal with the other 98% who are, you may have been a 5%, but they're going to reduce you down to 2 because you just need to get paid. And so it's very, very important for artists to understand their business, that the creative is got to be linked to the business. It's got to be linked in the round. And you have to make sure that you have good management and excellent legal representation, because it's very, very difficult to follow it all.
And Jeff,
Well,
those
thank you.
people with 10 people on the song, they're going to be hating their life 35 years from now when it's time for them to do copyright termination.
Well, yeah, because, by the way, it starts out with 4 people on the song, but you showed up with the sample. So now the sample's got 3 writers. So those 3 writers have to be compensated, and let's get the sample clear because we can't go anywhere until we get the sample clear. So you're just getting reduced and you don't even know it. You may have written, the lyrics, and the sample could be in the melody. But how it's divided up, all of those are conversations that need to be had as the creative process is happening. Not always convenient given the way the process comes together, but critically important.
It's not just that it's inconvenient. I think also what I see with clients is like they just don't feel empowered to claim their fair share. They don't want to argue about it or not be chosen next time to collaborate. And so, to Bernie's point, I think it's really important that they have competent counsel to guide them.
Incredible perspectives.